number 76, the people of the state of New York versus Manuel Rodriguez.
Good afternoon, Your Honors. Like, sure.
Moment, please.
Yes.
Good afternoon, sir.
I'd like to reserve 3 minutes for rebuttal, if that'd be okay. Stephen Strother from the Office of the Appellate Defender on behalf of Manuel Rodriguez. Manuel Rodriguez did not engage in a taking in this case. Instead, he withdrew money from his own bank account after a taking had
But to
already...
find that, I mean, this is a sufficiency case, right? So we all know the rules on a verdict sufficiency challenge. They get every reasonable inference, the people, right, most favorable. So to say he just took the money out, I think ignores the entire line of conduct up to that point, which is opening the account, checking the account, somehow getting a card to the person who actually puts the check into the account, and then withdrawing all the money.
So there's 2 points to the answer there, Your Honor. First is that the way the case is charged to the jury is that it's explicitly limited to the withdrawals. The court instructs the jury that on the date and the exact time on the withdrawal slips, he committed grand larceny. So the theory of the case, as the people had, assented to it being charged, is that it's about the withdrawal. Secondly, even assuming, taking into account the facts, the establishment of the account, the deposit of the check, at no point did the people proffer any evidence that Mr. Rodriguez knew that that was a stolen check. They actually conceded that he didn't know that. They say, we can't prove that he knew it was forged or stolen. Under those circumstances, there are many other reasonable inferences. And in a circumstantial evidence case, they have to exclude the other reasonable inferences.
So does your argument rest on the proposition that we're only talking about the theft or the taking of the check, not of the proceeds of the check?
No, we actually think that the evidence is insufficient, whether you call it the check or the money, as the prosecutor says that was their theory. Certainly, if it's the check, they have no evidence tying him to the theft of the check. Actually,
So let's talk about the proceeds then.
So as to the proceeds...
So when was the taking of the proceeds complete, in your view? When the check was taken?
I think that... there is an issue with saying the proceeds are a separate taking simply because there is no requirement under the law that you convert property into some other form before a taking is complete. But even assuming for the sake of argument that it is, the taking is complete at the point at which the money is in the bank account.
Well,
So you mean when the check clears?
When the check clears, because then it's your money. You can use it in some form. You can make it, use your debit card at a
but it's
corner
sitting there,
store.
and the owner and the true owner may discover this before you withdraw it, right?
It's possible.
Okay,
yes.
so at that point, they still have a superior right to possession of that money, even though it's now been cleared and it's in your account, right? Superior to yours?
Well, assuming that the property is stolen, the owner always has a superior right to it, no matter who is in actual possession of it. The superior right's a legal concept. But dominion and control is about who is able to use it at that time. If it's in your account, you have dominion and control over
What
the
about
money.
the bank? Does the bank have any dominion and control over it?
They maybe have a secondary right to do something with it, right? If they determine that you're about to overdraft your account, they can put a freeze on it or something of that form.
So you're saying once it's in your account now, your right to possession is greater than the person whose check was forged?
I would say that the right to possession under this circumstance is not quite the proper inquiry. The question is whether you've exercised dominion and control over the property. That is the critical inquiry, that's what determines whether there's been a taking.
Let me take a step back a second. Was there a charge given by the judge, a circumstantial evidence charge given?
Yes.
Okay. So given that there was a circumstantial evidence charge given by the judge to the jury, didn't they evaluate the nature of this proof? And really, aren't we right back where Judge Garcia said once that charge was given? If the charge wasn't given, I can see that argument, at least as an argument, but the fact that it's given seems pretty dispositive here.
Well, it's just, that would only be dispositive of the fact that he was convicted, not to whether there was sufficient evidence, because the question still is, was this ever sufficient evidence of a taking? Here, again, it was charged to the jury solely that the withdrawal of cash was the taking.
Going to that
There was a
point,
general instruction before that, right? A pattern
general-
instruction, and then there was a specific instruction.
There was the beginnings of the pattern instruction on grand larceny, and then he says that you must find that on or about this date at this time he committed grand larceny. So it's limited to those acts.
But it was a PJI, it wasn't a PJI, it was a CJI charge on circumstantial evidence, I'm assuming.
That's correct, yes,
Okay.
yes.
and isn't it the appellate division's conclusion that, one, they rejected the takings argument, but then they said, in any event, there was ample circumstantial evidence from which a jury could have reasonably inferred that the defendant participated in a scheme with at least one other person to steal the check, deposit it, and withdraw the money.
I think actually that conclusion is wrong for a few different reasons. The reason why is because, A, they have no evidence that Mr. Rodriguez ever stole the check. Again, the district attorney conceded at trial they did not have any proof of that. If he doesn't-
Why does that matter?
Because if he doesn't know that it's stolen, then helping
Why does he
him
matter?
deposit,
Why does it matter that he doesn't know the physical check is stolen?
because that means that when he helps him, if we think he helped him facilitate this deposit, he could have maybe thought that something fishy was going on, but that doesn't go down to
But there is
specific
evidence-
intent to steal.
It's a reasonable inference from the evidence that he was working with some other person, gave that person a card and a PIN number. No?
That's correct, but even from there, you can't necessarily draw the inference that he knew the check was stolen, which is required
He
to
takes all the
establish
money
grand
out
larceny.
right away. I mean, that's some indication he thinks it's stolen. I mean, as soon as it possibly will clear, one, the accomplice, let's call him, gets a couple of $100, but he takes out $11,000 and change within, what, a day? Isn't that some indication he knew it was stolen?
It is indication that he knew more than likely that something illegal was happening. However,
The
if
question
that's
is,
the case,
why isn't that enough? Not just that he took most of it out, if not 98.98% of it, but that he did it through these particular withdrawals in this particular way during this particular time frame. Why doesn't that get you to, that's enough for the jury to infer that, yes, he's part of a scheme?
I would say that a couple things. One, it's definitely not charged to the jury as a scheme. It's not charged in acting in concert. There's nothing like that presented to the jury. It's charged that he's the principal and that it's about the withdrawals. But going back to your question, the reason why it's not enough is because, again, in a circumstantial evidence case, you have to rule out other reasonable inferences. Here, if they concede they can't prove he knew it was stolen, then specific intent to steal isn't present in the record. And the reason why the rule about...
So what's the reasonable inference? $10,000 just mysteriously appeared in his account? He knew he didn't put it in.
it would not be a mysterious appearance. I think you could say that it could have been...
And see, even on top of that, in every case, you have to rule out reasonable inference. The standard is the same, beyond a reasonable doubt. What evidence gets you there? You have to rule out reasonable inferences of innocence. Of course, you got to rule those out. I think that applies with direct evidence, circumstantial evidence. It's how you get to that ultimate conclusion. I think that, see, when I look at the case, I'm thinking, I'm, in my own head, I'm saying to myself, is he arguing to me that there should be a different standard for circumstantial evidence cases than for direct evidence? Are you saying that?
I don't think we have to commit ourselves to that. I think what we're arguing is
Because
that...
if it's the same standard, it's the same standard of proof and burden, then that makes your case more difficult, doesn't it?
It can. I think if you can make a separate standard for circumstantial evidence cases solely because in those
I don't think that's
cases...
supported in the law, see, and the idea of moral certainty, and those concepts have been rejected on circumstantial evidence, so that's my concern with the case.
I understand. I think, if I may say real quickly, what I think the reason why it's important that we cabin the idea of a taking at when the money goes into the bank account is because of the fact that any other rule is pretty much unworkable. If his mere withdrawal of money is enough to establish a taking, if that's the taking, then a taking could conceivably continue for the lifetime of a bank account. Or if the funds were somehow commingled with other funds, then we would never know when they ended.
Isn't that all factual? Isn't that all for the next sufficiency case? We don't have that here. What we have is he opened the account, he gave somebody the card, he checked to see if there was anything in there, and then he took all the money out in suspicious withdrawals. the next day. So those may be interesting facts, but those aren't the facts here. So isn't this just, again, a legal sufficiency case based on what proof the government put in here?
It is a legal sufficiency case, but it is also a case in which this court is going to be, for the very first time, required to consider whether withdrawal of money from a bank account is a taking. That is something that has never been
Not
considered
if we
before.
go on the alternate ground the appellate division went on, which is under the circumstantial proof submitted in this case, there was a larceny.
The problem with the appellate division's finding is that it ignores the fact that the prosecution conceded that they couldn't establish that he knew the check was stolen, at which point you can't prove intent to steal. It's not possible for them to do that at that point. If you can't prove intent to steal, you don't have grand larceny. The appellate division's decision just ignores those facts. This court can't do that.
Well, why can't you prove intent to steal by showing that you intended to avail yourself of that money to the exclusion of its rightful owner?
Because if you can't prove that he knew the check was stolen, then that means the check may have been for payment of a debt. There are many other things that check could be for at the point at which you can't prove he knew it was stolen. He has to know it's stolen before helping someone deposit in his account becomes
But the
theft.
manner in which he made the withdrawals it certainly could, I think, lead to a reasonable inference. It would not be irrational for a jury to infer that he knew that that money wasn't properly there.
Even if he knows the money is not properly there, that actually doesn't establish grand larceny. It establishes something perhaps like criminal facilitation, where if you know a crime is probably being committed and you take action to help them, then you've committed that crime. I think this is one of our other points, right, that there are multiple other criminal offenses that this maps onto pretty well. Grand larceny is a very odd fit for this set of facts, and that's because this court's never really considered a case like it, whereas facilitation or money laundering maps almost exactly onto these facts.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, Valerie Figueredo for the people.
Counsel, could you start with your concession that the check wasn't stolen? Where is that?
The people below never conceded that we didn't have to prove defendant's knowledge that the check was stolen. What we conceded in summation was we didn't have to prove that defendant stole the check. And that's correct because as the penal
Physically
law
stole the
physically
check.
stole the check. And again, that is correct because the penal law recognizes a distinction between money and the check. They're two separate types of property. And this court in People v. Geyer recognized that money and a check are distinct forms of property. The jury was instructed that it had to find the defendant knew the nature of the money in the account, and the people proved that defendant in fact knew that the check that was deposited into his account was stolen. Again, you have defendant a day before the deposit creating an account at the exact same bank that KWC used. It was reasonable to infer from that he wanted the check deposited in the exact same bank so that it would clear quickly so that he could obtain physical possession of the money before KWC discovered that the check had been deposited.
Let's say we don't agree that even with what is ostensibly a favorable burden for the people on this appellate review, that you couldn't draw the inference about knowing that the check is stolen. What if he just thinks the money comes from illicit activity or illegal conduct? Would that be enough?
Even if you disregard the evidence we have showing that he knew the check was stolen, and if you disregard his participation in facilitating...
What I'm saying is, let's say he doesn't know that the deposit is by a check, but he knows there's money in this account.
As long as he knows there's money
That's what
in
I'm
the
asking
account,
you.
right?
Does it matter that he knows it's a check?
It doesn't
Is
matter.
the way the money got in the account?
It doesn't matter. All he needs to know is that the money was obtained unlawfully, and the unidentified man has to use him to obtain physical possession of that money. In that sense, this would be no different than if you were a shoplifter who had removed an item off the shelf. That's the unidentified man. As the unidentified man is trying to leave the store, he elicits defendant's help to get the property out the door. If defendant knows the property is stolen and still helps in that, People v. Robinson makes clear that one who participates in a larceny while the crime is ongoing is guilty of the larceny.
So what part of the, given what you've said, what part of the crime is ongoing? Why isn't he just the person who's got possession of the stolen goods?
Right. He's not just a mere possessor of the stolen goods because, again, he participated in the deposit, and the deposit was the means by which the money left KWC and entered defendant's account. Even if you ignore that and you focus just on the withdrawals, that would still be enough because in that situation, you have...
Why do the withdrawals matter at all?
And
And then in answering that, think about counsel's argument that the jury instruction is wrong?
The jury instruction was not wrong.
We'll start with why the withdrawals matter. That is,
The with-
suppose he'd taken the money, it sat in his account, and he didn't withdraw it. Is there still a larceny under your theory?
There's still a larceny of
The
defendant.
larceny's completed even before the withdrawals.
The larceny could be deemed complete even before the withdrawals.
Well, is it, or is it not? Could you prosecute him if he didn't withdraw it?
If he had participated in the deposit, as we proved,
Yep.
then he would still be guilty of the larceny, and we could have prosecuted
Okay,
it.
so do the withdrawals matter
The
at all?
withdrawals do matter, because the withdrawals not only show that defendant knew the money was unlawful, that was not rightfully his, it showed his intent to appropriate that money, and it also was the means by which they physically secured possession of the money. It was them essentially carrying away the loot. So the
So
withdrawal.
you're using the withdrawals essentially as proof of the larceny that was completed by the deposit, not themselves as larceny.
That's not correct, Your Honor. The larceny certainly could have been deemed complete with the deposit, and People v. Robinson makes clear that the fact that that liability could have attached for the principal at the point in time the deposit occurs doesn't mean that the crime is over for all purposes.
And so you think the jury instruction is correct?
The jury instruction is correct, because although the jury instruction focused the jury on the withdrawals, which again is a part of the taking, so it would be correct even on its own, nothing in the instruction precluded the jury from considering defendant's entire course of conduct over the span of the entire scheme, including his opening of the account and his participation in the deposit. In fact, the jury was instructed as to the general principles of larceny. It was told that it had to find that it was a theft from an owner, namely KWC, and it was told that it had to find the defendant knew the nature of the money. So nothing in that precluded the jury from considering the entire course of conduct on the ultimate issue of defendant's guilt of larceny. Defense counsel acknowledged that the taking was complete with the deposit. Going back to the facts, we proved there was ample evidence that defendant participated in the deposit. He had to have met the unidentified man to hand over the debit card, which he obtained the day before the deposit, and he was the only person who had the PIN number, so he had to have provided that. It was certainly reasonable to infer that defendant did that because he wanted to distance himself from the check. He didn't want to have possession of the check, and he wanted to participate in this scheme to steal the money. If there are no further...
But your position is he doesn't have to know there's a stolen check, right?
He doesn't have to know that the money that entered in his account was by means of a stolen check. The evidence here doesn't rule out that defendant did in fact know that. He must know that the money was stolen, and we did prove that defendant knew the money was stolen and in fact participated in the means by which the money entered his account.
Just to clarify, is your argument that the property that's stolen is the money, or the money is the proceeds of the check, which is the property that's stolen?
The property that was stolen is the money. It is no different than if you had stolen a key to a vault. We could have charged him with theft of the petit larceny for theft of the key. But what we charged him with was stealing what was inside the vault, which was the money.
But if he had stolen the check, you could have charged him with
That's right. It
grand
could have been
larceny.
overlapping larcenies. We could have charged petit larceny for theft of the check.
So if he stole the check, but he never attempted to cash it, would that be a taking
It would be a taking of the check.
of the
So-
check, but not of the funds that the check represents? Is that?
Well, again, this was a forged check, so it's valueless. It wouldn't represent any funds. If he had stolen a check that was actually made out lawfully by the KWC to a person who was entitled to that debt, then it would be, under the penal law, that check would have the value on its face. But that's not what we have here. In either case, if we had evidence proving his theft of the check from KWC, we could have charged that, and we could have also charged theft of the money once that money was removed from KWC's account.
So I'm sorry, maybe I've misunderstood what you've just said. You're arguing that there are two separate larcenies?
There could be two separate larcenies.
That's not how you litigated the case, right? That's not how you prosecuted the case, excuse me.
Our theory below was always focused solely on
One larceny, correct?
That's correct, on the theft of the money, because we didn't have enough evidence linking him to the theft of the check. Had we had,
So when did he take the money from the owner?
defendant took the money from the owner when the check was deposited. At that
But
point,
he didn't do that.
He didn't have
So
to.
your argument for that is because of what he has done to facilitate that being done by someone else? That's the scheme argument?
That's right. He didn't have to physically take the money. He was an accomplice to that, and he was an accomplice to that because he created the account, he gave his debit card, and he gave the PIN number, and all of that was needed for that money to enter that account. There's no distinction between liability as a principal and accomplice, so even if he was an accomplice, he would still be guilty.
Is it correct that you prosecuted this as the defendant was the principal? I know you're saying there's no distinction, but I just want to know your position on that.
We did prosecute it as if he was the principal, working with the unidentified man to steal the money. If there are no further questions, we ask that you affirm.
Thank you, counsel. Counsel?
Just getting to Judge Rivera's recent question there. The reason why it matters whether it's the money or the check is because if it's the money and the deposit is the point at which the taking is complete, again, he didn't actually deposit the money, and the judge did not charge acting in concert. The words were never actually mentioned during the trial once. And the judge specifically instructed not that the deposit was the taking, but that the withdrawal of the money is a taking. That's critical because at that point, the evidence only establishes that somebody else deposited the check, perhaps with Mr. Rodriguez's assistance. However,
Well,
the jury would,
certainly with his assistance, no?
I think it's a fair inference that he assisted in the deposit of the money. However, what the point being here is that the jury was not asked to determine, did Mr. Rodriguez act in concert to complete a deposit that is a grand larceny? They were asked to determine, did Mr. Rodriguez, acting as a principal, commit grand larceny when he withdrew money from his own bank account? If that's what the jury was being asked to decide, then certainly sufficient evidence wasn't presented to find him guilty of that. That is just not in the, there's no evidence in the record about whether there's no decision from this court that a withdrawal is a taking. And secondly, there's no instruction to the jury about acting in concert. There's nothing that they're deciding about him working together for a scheme. That's just not how this case was presented.
So why isn't it going to 155.05, you're focused on the taking. Why isn't it that he's withholding the property from the owner?
Withholding is usually used in slightly different circumstances than a trespassory taking, which is what we're talking about here. Their theory is that it is a trespassory taking, that the withdrawal of the money is the trespass. Withholding of money is often used in different circumstances than that. So I don't believe it would be a withholding crime, simply because withholding...
Well, he's certainly, it could be inferred by the jury that he is making it more and more difficult for the owner to be able to track this check and to get the money, right?
One could argue that, although there are circumstances...
By the quick turnaround on the withdrawals, once it clears, using the same bank so that it will clear quickly.
Yeah, I think there's a stretch inference that the use of chase really makes much of a difference in this case. There's literally a chase on every street corner in New York City, so to infer much from it is, I think, a stretch.
But it's not an unreasonable inference.
I would say it's an unreasonable inference to say that someone chose a chase on purpose when there's a chase on every street corner. That is so much more susceptible to innocent explanation.
Why is he going to Coney Island, then, to that chase? Within about an hour of going to another chase.
Again, Your Honor, we've conceded that it shows that he likely knew something was fishy about what was going on here.
Thank you, counsel.